Hello everyone, welcome back to my channel. I'm Ashkan Yekrangi, immigration lawyer based in Irvine, California. And in today's video, I'll be talking about a critical aspect of immigration that affects millions of immigrants every year in the United States, and that is adjustment of status. Specifically, the reasons that people can be barred from adjusting their status in the United States. It is important to know if any of these bars apply to you before you file for adjustment of status, because if you're subject to some of these bars, you may be ineligible. In some contexts, you might be ineligible, but a waiver is required. And in other contexts, the bar is automatically waived. So listen carefully. First off, let's break down what we mean by bars to adjustment of status. Think of these bars as physical barriers. Only in this context, they are legal impediments that can prevent you from becoming a lawful permanent resident. These barriers include unlawful presence in the U.S., certain types of criminal convictions, and violations of immigration law, among others. Each bar carries its own set of rules and exceptions, and it's critical to grasp these nuances to navigate the adjustment process effectively. Let's take it from the top. Unlawful presence in the U.S. This is a major barrier to adjusting your status. It basically means being in the U.S. without legal status for more than 180 days. This can lead to a 3-year bar from re-entry if you depart the United States. If you're unlawfully present for a year or longer and depart the United States, you face a 10-year bar. One scenario in which immigrants find themselves unlawfully present is after overstaying their visa. If you're filing your adjustment of status through an employment-based application, you're required to remain in status all the way until you file for adjustment of status. If you're filing adjustment of status based on a family-based application, if that family member is not your U.S. citizen spouse, you're also required to be in status at the time your adjustment of status application is filed. So in many contexts, it's important that you remain in status. The only exception to this is if your spouse is a U.S. citizen and you are adjusting your status based on that application. On a related note, if you entered the United States without inspection, meaning you did not have a visa or you were not paroled into the country, you are ineligible for adjustment of status. In these scenarios, you'll be required to file an I-601 waiver and receive your green card through an embassy. Now, let's discuss criminal convictions, which is another common way immigrants can be barred from status adjustment. Under immigration law, a person is said to be inadmissible if they have been convicted of a crime involving moral turpitude. These offenses generally involve theft, fraud, or drug offenses. There's an exception in immigration law for one crime involving moral turpitude, but it depends on the severity of the crime. In that case, you may be eligible for an automatic waiver known as a petty offense exception. If you're not eligible for this exception, you're required to file a waiver showing that your inadmissibility should be waived because your spouse or parent will suffer an extreme hardship. It is also important to note that any drug offense can have serious immigration consequences. With the exception of one crime involving simple possession of 30 grams of marijuana or less, any other drug offense will permanently bar you from obtaining an immigration benefit. Prior misrepresentations or lies to obtain an immigration benefit are also problematic. For example, if you lie to obtain your tourist visa, you're inadmissible to the United States. The only way to overcome this inadmissibility is by filing an I-601 waiver showing extreme hardship to your spouse or parent. Now, let's cover some of the most common questions. Number 1, how does being married to a U.S. citizen affect my chances of overcoming bars to adjustment of status? Spouses of U.S. citizens are considered immediate relatives, which grants them special consideration under immigration law. Generally, if you are unlawfully present and have not departed the United States, any period of unlawful presence is forgiven. If you have been unlawfully present, then depart the United States and re-enter, it's important to discuss with an immigration lawyer because you face inadmissibility or even a permanent bar. Number 2, how does unauthorized employment affect adjustment of status? Generally, unauthorized employment is considered a violation of status and can be problematic. However, if your spouse is a U.S. citizen, any period of unauthorized employment is forgiven and you do not face any immigration consequences. Many people lie about unauthorized employment because they believe it is problematic, but it is in this context being truthful is important because unauthorized employment is not a bar, but if the officer discovers you have lied, they may find you inadmissible due to the misrepresentation. Number 3, can I adjust my status if I have a pending asylum application? The answer depends on how you wish to adjust your status. If your spouse is a U.S. citizen, you are able to adjust status even with a pending asylum application. However, if you wish to seek adjustment of status based on another relative or a spouse that has a green card or even an employment-based petition, then generally you are not eligible for adjustment of status. However, there are certain exceptions in the immigration law, so you should discuss your exact situation with an immigration lawyer. Number 4, how do I handle denial of my adjustment of status application? If your adjustment of status application is denied, try to understand the reason for the denial and your options moving forward. You might be able to file a motion to reopen or reconsider the decision if new evidence or a change in circumstance can be presented. In other situations, it may be better just to refile your adjustment of status. Number 5, what impact does a past deportation order have on my current adjustment of status application? A past deportation order can significantly impact your ability to adjust your status. Having a deportation or removal order on your record can result in a bar to re-entry, ranging from 5 to 20 years or even permanently, depending on the circumstances of your case. If you have a prior order of removal and have never departed the United States, you should discuss your case with an immigration attorney to reopen your immigration court case to have the removal order rescinded. Number 6, how does the public charge rule affect my eligibility to adjust my status? The public charge rule has been the subject of a lot of debate. Generally, as long as you have a financial sponsor and you demonstrate that you will not rely on government benefits, you should be fine. If you found this video helpful, please don't forget to like, share, and subscribe to stay up to date on the latest immigration topics. Thank you for watching, and I'll see you in the next video.